Please, Your Lordship. Your Lordship, I beg to mention item number 15.
You have asked for a mention.
15 and 16, Your Lordship. If the conducting counsel is
15,
out of
16?
station. 15 and 16, Your Lordship.
Connected matters.
No, not Your Lordship. It's a different matter.
Then one at a time.
Okay, Your Lordship. 15.
You're appearing for?
Respondent, Your Lordship.
Who's for the petitioner?
Sir Titi Dingdo, I believe, Your Lordship.
He's not here. We'll wait. Let it be called up.
Okay, Your Lordship. Your Lordship, item number 16, Your Lordship.
16. What remains?
Made 16. Made this is your Lordship. Lordship, there was an order asking me to do something for the betterment of the school as well as for the people. That has been done. It has happened, Your Lordship. There was a meeting on my instruction. There was a meeting on 23rd August 23, Your Lordship, in the office chamber of the Subdivisional School Education Officer. Some result has come out, Your Lordship.
Beneficial to all or only to?
Your Lordship, yes.
They are trying to resolve the entire
They are
dispute.
trying to resolve the real petitioner will have to tender apology to the village authority and all. Then
That is nothing. We apologize for each and everything, so it makes no difference.
so now so far the duty of the state is concerned, Your Lordship. We have done our part. Your Lordship. It's for them to take a call now.
So we'll do one thing then. Is there any timeline, or have you conveyed this message to the petitioner?
Your Lordship, no,
I have instructions on that, but the report will be furnished to me.
They were present.
I was
All of
present
them,
there.
All they were present.
In fact, she has expressed her willingness to apologize if there any fault on her part. Because of that,
They are aware, Your Lordship. They were aware of the result, the contents, everything. They were aware. All the party, all the
So what do we do then?
so now, Your Lordship, only formality left on my part is that I'll have to write an apology, tendering my apology. And at the same time, the managing committee also ought to have withdrawn the termination letter, all that. All those are consequences that
So
come
we'll leave
later.
it then 1 week or 2 weeks?
Well, will be too short, Your Lordship.
2 weeks.
2 weeks. Or maybe 3 weeks.
Lordship, now is the ball is on them, Your Lordship.
Because they'll take the matter to the Darbar Shinong, and Darbar Shinong will
Let it
deliberate.
be 3 weeks, Your Lordship.
Three
We
weeks.
say, let it be 3 weeks.
As submitted by the Learned Counsel for the petitioner, as well as Mr. N.D. Shulai, Learned AG, appearing for the state respondent. It appears that there has been some breakthrough in this matter as far as a possibility of settlement is concerned. Though the details of such settlement is not clear, the parties have sought for some time to sort out all the formalities and to file a report before this court. So you file a report.
We are giving right now, Your Lordship.
No, you see, Mr. Nogri, what you do is, after you have tendered your apology, whatever is done, if there is a response from the manager property or the government for that matter, let a report be filed. And if there is any terms of settlement, so on and so forth,
On that count, I'll file a small affidavit on
yeah,
that,
you file an affidavit and then it will be taken on board.
Your Lordship.
As prayed for, this is matter of the 3 weeks.
After 3 weeks, Your Lord. Let it be up.
So 3 weeks.
3 weeks.
Oblige, Your Lord.
Oblige.
Highly obliged. Your Lordship, item number 15. We pray for time, Your Lordship. The conducting counsel is out of station.
Yeah, Mr. Dingdo is here. So,
This was part of anyway, man, since personal difficulty.
on premise by the respondent, on grounds of personal difficulty on the part of the Senate conducting counsel, the same not being objected to by the appellant, that is adjourned. How long?
2 weeks, Your Lordship.
This is a matter to 2 weeks.
Highly obliged, Your Lordship.
Well, item number 17, I'm for the petitioner, my lord. In this matter, my lord, I've been instructed to withdraw the matter, so I've informed my colleagues. So they have no objection,
So
madam.
let the matter be called up.
Madam.
Lordship, I beg to mention item number 8. The conducting counsel, Mr. H. Abraham, is indisposed. The other side is Mr. K.P. Bhattacharya. We'll inform him.
On pre-made by the respondent. This is not up to
A week,
1 week.
if you obliged.
Yes, my lord. Lordship, I beg to mention item number 9.
This is
Lordship, I'm
You were not there just now in the division bench.
By that time I reached one of the matters.
praying for 1 week, your lordship.
2019 matter. You cannot just. On pre-made by the respondent, petitioner, not being objected to by the respondent, that is adjourned. Let's say after 1 week. Be sure to
Obliged.
get this matter disposed of. Why?
Similar prayer for item 10, my lord.
This is also 2019 matter.
may it please your lordship. Lordship, so far item number 10 and 11. 10 and 11, your lordship. These are lordship government lease land, your lordship. Their lease had already expired, and there was an government had taken a policy decision to resume the land, your lordship.
10 and 11.
10 and 11, yes, your lordship.
Okay. So we should dispose of this matter.
In fact, your lordship, in the writ petition number 423/2019, that Jani Devi, your lordship. This is the second round of writ petition. They filed a writ petition, and this court was pleased to WPC number 423, your lordship. In item 10, your lordship. This court was pleased to dispose of the writ petition, directing the authority to take a call on the representation submitted by them. That has been taken, and a detailed order has been passed. So against that order, the second writ petition has been filed, your lordship.
So we'll hear it next week.
Lordship, if I pray, your lordship, if the matter can be taken up on next week on 12 or 13, your lordship.
Fine. 13,
13.
on pre-made by the parties, let's this matter on 13. That's for 10 and 11.
10 and 11, your lordship.
10 and 11.
Lordship, similar prayer for item 12.
Apply, your lordship.
My apology, your lordship.
I don't know. If this is the rate we are going, then nothing can be done.
Number 12, I've been persistently objecting to that. But what to do with it, especially nowadays with the live streaming and all that, and clients are aware. I know I can understand the difficulties of the council, but
You're appearing for
The petitioner, your lordship.
petitioner.
12, respondent.
Respondent.
You don't even know yourself.
My apology, your lordship.
It's a simple matter, no? It's just under Order 7, Rule 11, rejection of a claim. Let there be a order that definitely in the next date should be.
These all matters should be disposed of.
One moment, your lordship.
As far as we're concerned, I think we have, of course, not, not exactly, set up a rule, but we have made it. Rather, we have put it, on ourselves. As far as we are concerned, that matters should be disposed of, within, the outer limit of 2 years.
A convention sort of.
So if that, you see, if we can, adhere to that resolution, so to say, would be better. But we are not getting help from the council.
I'm not blaming my.
No, I'm
junior
talking
friend,
generally.
but,
Generally.
an endeavor should be.
But please do. Otherwise, next time you have a array of counsels appearing for the party. If one is not present, the other should be. Accommodation has been sought for by the respondent on grounds of personal difficulty faced by the head conducting counsel. The head senior counsel appearing for the petitioner has not raised any strong objection, but has, however, pointed out that this matter is long pending and the same should be disposed of expeditiously. The accommodation sought for is allowed. However, the parties are requested to ensure that the matter is heard positively on the next day. How long?
1 week.
This is matter to 1 week.
On daily cost list, item number 1.
May I please, Your Lordship? My Lord, if my Lord may kindly come to page 23, Annexure 3, my Lord. Yeah, my Lord, this is the forwarding report, my Lord, of the IO when I was arrested.
May it please your Lordship. Lordship, in fact, in the last order, I was directed to submit the report, Your Lordship. In this matter, Your Lordship, item number 3, 4, and 7, these are no occurs, Your Lordship. In view of the order passed by Supreme Court in bail application number AB number 49 and the full bench decision order of 29A, Your Lordship. The state does not need for the custodial interrogation of the accused, Your Lordship. Only, Lordship, the condition as may be imposed by this court as well as by the full bench, Your Lordship, may kindly be.
Where is the yes, if I remember correctly,
Lordship.
there was a matter, with regard to the same subject matter here, which for which bail has been applied before this court, rejected.
Rejected, and they went to Supreme Court.
This is the order.
Then Supreme Court. Lordship.
Where is this?
Lordship, in that order passed by the Honorable Supreme Court, Your Lordship, the condition were directed to be imposed by the trial court, Your Lordship.
Oh, because it is the Supreme Court who is passing the order.
Lordship, yes.
So we'll follow this, since you have made your submission.
Lordship, if Lordship is because Lordship, I'm also relying on this court order of dated 1/9/2023, Your Lordship. If Lordship is pleased for the moment at paragraph 6. In Sumit Kumar Akarwal, Your Lordship, that Lordship kindly come to para 6 and the condition number I. He shall not abscond tamper with evidence or witnesses. He shall cooperate with the investigation, and in this case shall furnish his mobile number, wherewith he shall may be contacted at all time if required. So this condition may kindly be.
We have no objection. We will comply with any condition.
And
Or Mr. SD, counsel for the petitioner.
3, 4, and 7.
7.
Brief facts of the case, according to petitioner, is that an FIR was filed, was lodged, an FIR dated.
FIR dated
16/12/2022.
Where is it?
12/22, Your Lordship.
Where is the FIR?
FIR is Annexure 1, my lord.
Page?
Page 21, my lord.
No. Brief facts of the case, according to the petitioner, is that an FIR was lodged. Dated
17/12.
17/12/2022, was lodged before the officer in charge, Shanang Police Station, by the ADC -SDO
Civil.
under bracket civil, Motion
Motion
Road,
Road.
civil subdivision. Indicating therein about the process, about the ongoing process of shutting down of 57 numbers of illegal coke plants within West Khasi Hills district, for which steps was duly taken by the authorities concerned to find out the owners of such pork plants and to proceed against such owners in accordance with law. Next, accordingly, Shalang PS case number 39/12/2022 under section 188/34 IPC was registered. Next, in course of investigation being launched, the investigating officer had summoned the petitioner here. Is it the petitioner or
It is the father of the petitioner, my lord, of the accused.
summoned the accused person herein to appear before him? Summoned you. Mention 241. Pursuant to notice
Dated 29/5.
notice dated
29/5/2023.
29/5/2023, issued under section 41A of the CRPC. In course of in such course, the IO has thought it fit to arrest the accused person therein and to remand him to judicial custody. The petitioner has then approached this court with this application for grant of bail to the accused person. Without going to the merits of the petition, at this juncture, the Mr. Additional Learned AAG has fairly submitted that this matter, being identical with other matters which was taken up by this court, has been dealt with adequately in AB number 49 of 2023, wherein by the order dated 1/9/2023, this court in such case has granted pre-arrest bail to the petitioner therein in connection with the same FIR mentioned above, in connection with the case registered as a result of the said FIR mentioned above. The learned AG has also apprised this court that in a similar application for grant of bail made by some co-accused before the Honorable Supreme Court, the Honorable Supreme Court, by order dated 28/8/2023, has allowed the prayer made for bail on the ground that the prosecution has found it unnecessary for the said accused person to be incarcerated in custody. further submitting that the order passed by the Honorable Supreme Court will be also applicable herein. The learned AAJ has submitted that there is no objection to the prayer made for grant of bail in this case. However, it is submitted that strict conditions may be imposed in case this court is pleased to grant the prayer for be pleased to grant bail as prayed for. This court, on perusal of the said order dated 28/8/2023, passed by the Honorable Supreme Court in special leave to appeal under bracket CRL number 9177/2023, and also this court's order dated 1/9/2023 in AB number 49 of 2023, is convinced that the petitioner has made out a case for grant of bail. Accordingly, the accused, I can take more to accused person. Is hereby.
Accused name is my lord.
Anyway, we'll go to from the petition. I think is it? Have you noted in the petition?
Yes, yes. My lord, may kindly come to the prayer portion, my lord. Ashish Arya.
This one is hereby
ASHISHARYA.
directed to be released on bail on the following condition. Itu condition anak betul ke juk wayo. Itu will give the same condition.
Lordship, yes.
Tu akan nikah 49. Petition disposal.
3, 4 and 7, same
Only
order.
the name of the accused will change, my
name
lord.
of the accused will change.
And number 7, my lord, item number 7, it is the brother. These two are fathers who are the petitioner before this honorable court. And on item number 7 is the brother who was before this honorable court. And only the name will change. my lord.
Same order.
Same order, yes. Same order.
Apply, your lord.
That is 3,
3, 4 and 7, your lordship. 3, 4 and 7.
7.
Lordship, yes.
Item number 5.
Please, Your Lordship. I have specific instruction from the senior counsel, Your Lordship. I have specific instruction from the senior counsel, Your Lordship. Lordship, let the matter come at 2, Your Lordship. Bring for Passover, Your Lordship.
What is this matter about?
This is a real question regarding Shalang.
This is the same matter we heard just now, Mr. Snukon.
My lord, Mr. Kharmi, I think he was appearing in this case. He is not here.
I think it should be because from the look of things.
My lord, same matter. Because this order reflects.
Just look, have a look. Let's have a look at the FIR.
Page 13, my lord.
Page
13.
Yes, same order. Why do you have to look for your senior? You could have done it yourself. You should have that confidence. You go through and you see, be alert on what is going on. The previous matter is exactly similar to your, identical and similar. You could have taken advantage of that and just, you don't even have to open your mouth. Right. So, right.
Item number 6.
My lord, in this case, the charge sheet was taken note by the court on 38th case 2023. They are entitled for the call bail only. beyond 90 days prison.
Why is the investigation so slack? It's a very serious matter.
It's not under NDPS, It's not under NDPS.
Not NDPS.
Not under NDPS. Is it 376?
376, Malot.
376 or not POCSO?
Not POCSO. Two adult Malot getting into some romantic relationship, which of course turns sour later on.
But they
That led to they were known to each other. In
But
fact,
that anyway, that
and
it
in
could
fact,
happen
Malot, it is off the record. The complainant never wanted to file this FIR. It was under the pressure from the family she went and lost this FIR. That is off the record, of course.
My lord, without, if we go through this statement, my lord, even though they are entitled for default bail, but case says otherwise, my lord.
No, exactly. I've just gone through the FIR.
Yes.
Yeah, like you said, you see, it's a matter of trial and evidence.
Absolutely, absolutely.
But it doesn't behove even the court to, look the other way. If this kind of matter is brought to the notice of the court.
Perhaps, my lord, because of that very reason, my lord, the investigating authorities were given ample time in this matter to investigate, and they waited till, in fact, more than 90 days for the investigation to complete. It was not that, unlike other cases where bails are granted after 30 days or 60 days. In this case, ample opportunity was granted to the investigation, perhaps because of the allegation made.
You were in custody for
more than 90 days, my lord. It's I was arrested on 31st of May. Today we stand more than 90 days.
The accused and victim, my lord, they were not known to each other from very long time, maybe just a week time only, not beyond that.
The first part of the FIR, my lord will see that they went to the local hotel, they sat there, they enjoyed a cup of some bottles of some finest wine, and then everything turned out from there, my lord. So it's not a case of, but of course, like your lordship said, it's a matter of trial. Everything remains a matter of trial now.
Heard Mr. Sapal, counsel for the petitioner. Also heard Mr. Anson Conrad, J, appearing for the state respondent. From the records, including the case diary placed before this court, what is noticed is that an FIR was lodged before the officer in charge, Umsning. Yes, it's Umsning.
It is, my lord, here.
Umsning Police Station,
Umsning.
Ribhoi District, wherein the complainant therein had alleged that she was sexually assaulted by the accused. The petitioner is not the accused, isn't it?
No, my lord, his brother is the
By the
petitioner.
accused.
The accused name is my lord, Tao Ting Panmai Dinning. Outing Panmai Dinning.
It's paragraph 2.
It is mentioned.
It's in the petition only, not paragraph 2.
By the accused, name paragraph 2 to Tauchang
Outing Panmai Dinning.
dining or dining.
Dinning.
Accordingly, Women PS case number 32 under bracket 5 of 2023 under section 341/354/376/323 IPC was registered. The accused, in course of investigation, was arrested and is now in judicial custody. The merits of the matter not being pursued at this point of time. The only ground raised by the petitioner is that he was in custody for more than 90 days, within which time the charge sheet has not been filed, in spite of the statutory and mandatory period of 90 days fixed for the same. In fact, from the order of the Leonard Judicial Magistrate First Class, Riboy District, the IO has presented the charge sheet, has presented the final report under section 173, including the charge sheet, on 38/2023, though the date which appears in the said report is 23/8/2023. The Leonard Council has submitted that the fact that the said charge sheet was acknowledged by the court on 38/2023, it can be presumed that the charge sheet was filed well after the statutory period of 90 days. Mr. Sinkon, I think I've requested you to find out the the position of law as far as this aspect is concerned. Whether the date in the charge sheet, if it reflects in this case 23. If it is 23, then it's well within time. But then when it was presented before the court and acknowledged, it was after a week or so, which is 30th. What is the situation there? I couldn't find any.
In my humble submission, it should always be the date on which the court has taken note of it.
Yeah, that
why I'm saying this is, my lord, the investigating agency may write even 2020 for that matter, but that will not, my lord, will not be considered to be filed on 2020. So that
do you have
they may, because they are in a position to give a back date only to frustrate the default bail. It is always the court when it takes note of, as Lordship has rightly pointed out earlier. Of course, my lord, authorities we could not cite.
There must be some. I recall.
Try to find out.
That would be much better, because in a sensitive case like this. In fact, I had requested only on this point, if you could have just brought out some authority.
If the law says otherwise,
as far as default bail is concerned, you see, Rakesh Kumar, Paul, and others are, it's well settled. No, there's no quarrel with
Only
that.
on the point of the date,
Only on the point of, see, whether
it will be counted
it will
from.
be counted from the date it was noted down in the charge sheet or the report, or on the date when. More often than not, I am also convinced that it should, the date where the court take cognizance of is to be
As far
taken.
as filing of charge sheet is concerned, my lord, that will be counted
When it
when
was
the file
presented to the
charge sheet
court.
is presented before the court.
Exactly, but
It should
where
be
is-
from that date.
where is the authority for that?
Well,
Can you do it within,
And only difficulty.
I'll just keep the order on hold.
my lord.
If you can do it within 1 hour or so,
We'll try to find out. My
We'll,
lord.
we'll do, try to find out. my lord.
you have your resources.
My lord.
Or let it come up at 2, my lord. If your
Not
lordship-
necessary, not necessary. The order will be
My lord
passed.
may pass an
in due,
order.
in due course, order will be passed, just for the satisfaction of this court that get relevant authority.
We'll
We'll
submit
supply
it
to
To the
the
court,
court.
court master. Please do that.
Only the conditions, my lord, if, my lord, of course, your lordship is already done with the order. If you could know the conditions, my lord, that would have been
Condition would be the usual.
as usual. And also, my lord, it was my humble prayer, my lord, if the orders could be supplied to us, my lord, today itself, because tomorrow is the only day we have for the acceptance of the bail bonds and all, because day after tomorrow and the day after tomorrow is a holiday, my lord. So if it could be provided on an application today itself, my lord, I would be
Because
highly
you
obliged.
have, firstly you have to apply for a certified copy.
Correct.
And only if you
We'll apply it today itself, my lord. If some endeavor could be made from the registry side, my lord, to supply us the copy today itself, because then we are left only with tomorrow, my lord, for the purposes of acceptance.
you cannot. It's not accepted. Accepted if you download it from the net and get it
My lord,
printed. Or
sometimes they do, but sometimes they insist on a certified copy. So again, we would be in a fix if they ask for or call for a certified copy, my lord. That's the only issue.
okay.
Obliged.
All right.
Just pass the order.
Item number 13.
If it pleases your lordship, the matter is being conducted by Philemon Nombri, your lordship. Your lordship, he is currently on legs in court number 2, your lordship.
So, and done. End of the board.
No. Right.
14. Item number 14.
14 as well, your lordship. 13 and 14.
They are connected.
Your lordship, the conducting counsel, Mr. Philemon Nombri, your lordship, he's having a hearing in court number 2, your lordship. Kindly put the matter on for after 2 weeks, your lordship.
What is this matter about?
Lordship, this is the case. So far, there continuous concern. It is a case of suspension. So far as state is concerned, it is a case of abandonment of service.
Abandonment.
Yes, Your Lordship. That is the issue to be.
Oh,
Because what happened, Your Lordship? 2 of them and 1 secretary, they split from the original school and established another school, and then they went to teach in that school. So it's the order of suspension, to my submission, Your Lordship, it was wrong. It should not have been issued because they have abandoned by going to that school. That school in which they had taught, Your Lordship, it's neither recognized nor or currently received from the government, Your Lordship.
so it's a private school.
Lordship, it's a so to say, Lordship, is a parallel school, same name.
Oh, same name.
Same name, Your Lordship. That then a decision was taken by the government recognizing the school run by the private respondent. That means the Roman Catholic institution.
Your Lordship, I'm limited in my submissions, Your Lordship. I am unable to object as the conducting counsel is not available here, Your Lordship.
Then 1 week then,
Lordship.
Not
2
further
weeks
than
if
that.
possible, Lordship.
on pre-made by the petitioner on the ground that the learned conducting counsel is indisposed. Matter is adjourned. This is after 1 week.
I do oblige, Your Lordship.
After a week, Your Lordship.
After a week. This is 2020 matter.
Or if
13 and
Your
14,
Lordship
Your
is pleased to fix it on 21st.
No, we'll not see. We'll see because how the
Lordship.
boat is is.
Lordship, ask your
I
Lordship.
cannot see right now.
This is
As per Your Lordship.
Oblige, Your Lordship.
Oblige, Your Lordship. Item 13 and 14, Your Lordship.
13 and 14 are same, Your Lordship. Two of them, Your Lordship.
Fine. 13, 14. Same whatever.
Item number 17.
I do oblige.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship, the petitioner didn't want to pursue with the matter. I humbly pray for withdrawal of the case.
The counsel for the petitioner has submitted that the petitioner no longer wishes to pursue with this matter and has prayed for withdrawal of the same. On pre-made, this petition is disposed of as withdrawn. What does it matter? Withdraw means withdraw. You have pale in significance. Item 5 take into. Item 5 is pass order. Three, 4 month. See order.